Honor, I am here to represent my client, a young man who was subjected to a non-consensual act of anal penetration. The incident left him physically injured and emotionally traumatized.
Counsel, the court acknowledges the disturbing nature of the allegations and the trauma the defendant has endured. However, the charge has been brought under Section 377C of the Penal Code, which criminalizes carnal intercourse without consent. The current legal definition of rape under Section 375 of the Penal Code is indeed limited in scope, recognizing only penile-vaginal penetration committed by a man against a woman. As a judge, I am bound by the laws as they are written, not as they ought to be. As such, the charge under Section 375 cannot be sustained. The only applicable remedy available falls under Section 377C. Accordingly, the court must proceed on that basis.
Good morning, everyone. We're live on Record Report. As of today, the court's controversial decision has caused public outcry. Let's hear it live from Keshviena.
Yes, that's correct. The court has proceeded with charges under Section 377C in a case involving a male rape survivor, due to the limitations in Malaysia's penal code. What do you think about this decision, Ms. Vaishnavi? Do you think this is fair?
I don't believe it's fair. My client was raped, but because he is a male, the law refuses to call it what it is. This isn't just a gap in the law, it's a human rights failure. He experienced the same trauma, the same violation, yet he received only half the justice. Good morning, everyone. My name is Vaishnavi, and I will be starting off with this presentation. Tarana Burke, founder of the Me Too movement, once said, "We owe survivors a path to healing and a sense of justice, no matter what the justice looks like to them." According to the data from Bukit Aman's Criminal Investigation Department, incidents of sexual harassment and assault against men in Malaysia have increased by 64% from 82 in 2021 to 135 in 2022, revealing a serious gap in legal protection for male victims under present rape legislations. Currently, Malaysian law defines rape as an act committed by a man against a woman, excluding male victims from legal protection under rape statutes. Given the increasing number of cases of male sexual assault, this discussion seeks to assess the effectiveness of Malaysia's rape laws and investigate whether a more inclusive legislative framework, such as that of England and Wales, is required to protect all victims equally. This presentation is part of an Impact Lab-led project called Peace, Justice and Strong Institutions, which seeks to remove legal injustice and promote fair treatment for all victims of sexual violence. Let me ask you, is it acceptable to have a legal system that protects certain victims based just on their gender? I'll be passing it on to Ebony.
Thank you, Vaishnavi. I'm Ebony, and I'll be contributing to the conversation on whether the laws on rape for males in Malaysia require a change. The short answer, yes, and here's why. Let's begin with Section 375 of the Penal Code. Under this section, rape is strictly defined as a man having sexual intercourse with a woman against her will or without her consent, meaning only males can be rapists and only females can be victims. This definition is clearly discriminatory and outdated. It completely excludes male victims of rape from legal recognition. What's more, it's a colonial-era provision, inherited from British law, which even the UK has since moved away from. Many countries have updated their laws to make the definition of rape gender neutral, recognizing that rape is not about gender, it's about non-consensual sexual violence. Malaysia, however, still clings to a definition that erases male victims. So where do male victims turn for justice? Sections 377A and 377C come into play here. These provisions criminalize carnal intercourse against the order of nature, which includes acts like anal and oral penetration. Section 377C addresses non-consensual acts and carries a punishment, but it's less severe than 375. And here's the issue. These sections don't call it rape. Male victims are still not legally recognized as rape victims, and that has serious implications in both how cases are prosecuted and in how victims are treated by society and the justice system. When we use different legal terms for the same traumatic experience, just based on gender, we're essentially saying that some victims matter more than others, and that's not justice. Let's look at why this framework is fundamentally unfair. First, the definition of rape is restricted to penile vaginal penetration. But what if a victim is penetrated with fingers, objects, or forced into oral sex? These are all deeply violating acts, and they should legally be called rape, regardless of gender or the method of penetration. Next, Section 377A doesn't even consider consent. Even if two adult men engage in consensual sex, they can still be prosecuted. That's because the law criminalizes the act itself, not whether it was forced. This approach doesn't protect anyone. It only reinforces outdated moral judgments. Moreover, male victims may hesitate to report due to the fear of being criminalized or mocked. Here's the core argument. The law should focus on protecting people from non-consensual acts, not criminalizing private consensual ones. And when someone is sexually violated, regardless of their gender or the form of penetration, they deserve for that act to be recognized for what it is, rape.
Thank you, Ebony. My name is Bethan, and today I'll be talking about this topic's relation to human rights and the real-life impact of how our laws treat male rape. Quickly adding on to why Malaysia's current rape laws are unfair, it is important to recognize how these shortcomings conflict with fundamental human rights under the Federal Constitution of Malaysia and international instruments such as the Universal Declaration of Human Rights. Under Article 8 sub 1 of the FC, it is stated that all persons are equal before the law and are entitled to the equal protection of the law. Likewise, Article 7 of the UDHR affirms that all are equal before the law and are entitled without any discrimination to equal protection of the law. When male rape cases are investigated under 377C, it downplays the seriousness of the crime and denies male victims their access to remedies afforded under rape. An important principle under criminal law is that everyone should be equally protected from harm of similar degree, no matter the penetration of a male or female body and gender of the actor. Aside from the right to equality, we must also consider the right to life under Article 5 sub 1 of the Federal Constitution. According to the landmark case of Tan Teck Seng, life does not refer to mere existence. It incorporates all those facets that are an integral part of life itself and those matters which go to form the quality of life. By failing to provide proper legal recognition and remedies to male rape victims, the constitutional duty to safeguard their right to a full and dignified life is neglected. But the current laws do not reflect this, stigmatizing male victims by associating their trauma with criminalized behavior. It denies male victims the right to live with dignity, safety, and equal protection of the law. Now, what does this message send when the law treats male rape as an unnatural act rather than a violent crime? This highlights the very essence of the problem, that the law does not recognize such an act for what it truly is, a serious violation of bodily autonomy. With this, the consequences are far-reaching for both male victims but also society as a whole. Unsurprisingly, male rape remains significantly underreported, not because it happens less, but because they fear judgment, being overlooked, and disbelieved. Even seeking medical help after rape can feel unsafe for male victims due to fear of negative reactions. Other than that, many fear of being accused of homosexuality, especially in Malaysia, with the lingering stigma from how 377A and 377C were fundamentally created to criminalize LGBTQ+ acts. Moreover, the glaring lack of research on male victims makes adequate resources scarce. Resources like victim support groups, medical help, and mental resources. It is evident that the false common consensus was that male victims could not be raped. This is problematic because with a lack of adequate resources for victims to utilize, they may not come forward as much as their female counterparts. Some researchers estimate that support systems, psychological help, and research on how to appropriately deal with male victims is more than 20 years behind their female counterparts. Furthermore, classifying what should be considered male rape as merely an unnatural act reinforces harmful gender stereotypes. Studies propose that it is the inflexible roles expected of men that drive the disparities in belief about rape between men and women. While women are often allowed to adopt more traditionally masculine traits, men are still expected to be strong, unemotional, and always in control, leaving them no room to express vulnerability and be seen as actual victims of sexual violence. Now, I'll be passing it on to Keshviena.
Thank you, Bethan. I'm Keshviena and I'll be presenting the comparison between the jurisdiction of UK and Singapore with Malaysia. In the UK, the Section 1 of the Sexual Offences Act 2003 is not gender neutral, as this offence can only be made by a male because they relate to penile penetration. However, Section 2 and 3 protects male victims from female perpetrators, and it is gender neutral. According to a journal article by Philip N.S. Rumney, one male victim who was raped in the 1960s quotes, "I knew it wasn't right because I felt so awful afterwards, but I didn't know what it was because nobody had heard of male rape those days." This quote reflects the historical silence surrounding male rape and the lack of legal and social recognition for male victims. Rumney argues that the fundamental characteristics of gender-neutral rape reforms is that they expand the definition of rape to include both male and female victims and perpetrators. In a sense, the term neutral refers to not to ignore gender, but to ensure that all genders are equally recognized and protected under the law. Male rape was first recognized under the English law in 1994, when the definition of rape was revised so as to include non-consensual penile anal intercourse of a woman or a man. Additionally, the SOA 2003 extended the definition of rape to include penile penetration of the mouth, based on the trauma that such assaults can cause. Importantly, the broader reforms introduced under the 2003 Act also encompasses scenarios where a woman coerces a man, woman, or a child to penetrate her, thereby expanding the legal recognition of female-perpetrated sexual violence. These provisions acknowledge that rape is not exclusively a male-on-female crime, but a violation of a person's bodily autonomy regardless of gender. As Rumney notes, this historic failure of the legal process in most jurisdictions to recognize rape outside the male-on-female paradigm may have also contributed to failure of society to acknowledge male sexual victimization. This highlights why gender-neutral rape laws are essential, not only for securing justice in court, but also for changing social attitudes and validating the experience of all victims. Similarly, in 2019, the amendments of Section 376 of Singapore's Penal Code expanded the law to recognize male victims and female perpetrators, reflecting a broader understanding of trauma across gender. The Singapore's adoption of gender-neutral legal framework sets a regional example, demonstrating that comprehensive protection against sexual violence is both necessary and achievable. Therefore, Singapore's move to a gender-neutral legal framework shows that even regional neighbours, not just Western countries, have modernized their laws, making Malaysia's continued use of gender definitions under Section 375 increasingly difficult to justify. Thank you, and I'll be passing to Reese.
Thank you, Keshviena. I'm Reese, and I will gladly conclude this presentation. In short, the case of Chang Wan Chuan and public prosecutor highlights the limitations of Malaysia's current legal approach to male sexual victimization. By prosecuting male rape under Section 377C rather than 375, which narrowly defines rape as a crime only committed by men against women. The law continues to reflect a deeply entrenched gender bias. This outdated distinction not only mislabels the offence, but also denies male survivors the recognition and justice they deserve. As pointed out by senior law lecturer Reza Zakaria, Section 375 is archaic in its assumption that men are always the aggressors and women always the victims. In contrast, countries like the United Kingdom and India, whose legal systems heavily influence Malaysia's penal code, have already taken progressive steps to recognize male rape and adopt gender-neutral definitions of sexual offences. Malaysian rape laws are in urgent need of reform to reflect the realities of sexual violence and to ensure equal protections for all victims, regardless of gender. The Article 52 proposed amendments to the law of rape in Malaysia has provided the following reforms. Firstly, repealing all laws that criminalize consensual sexual activity between adults of the same sex
Secondly, ensuring that gender criminal provisions are not misused to penalize private consensual acts based solely on sexual orientation. Lastly, adopting a gender-neutral definition of rape so that all survivors, including male and LGBTQ individuals, are equally recognized and protected under the law. Without these reforms, the law remains lawful, but not just. Real fairness requires real change.